Good morning, good evening, or good afternoon. Welcome to the panel titled as Electoral Democracy and the Rule of Law. This panel is organized by Law Association of Asia and the Pacific, LAWASIA. My name is Yasushi Higashizawa, co-chair of Human Rights Section of LAWASIA. However, this panel is a part of more comprehensive and ambitious event, originally organized by three organizations: Union Internationale de Avocats, UIA, American Bar Association International Law Section, ABA-ILS, and Association Internationale de Jeunes Avocats, Human Rights Committee, AIJA. The events are collectively titled as Lawyers Around the World, Around the Clock for Rule of Law, a Rule of Law 24-hour Webathon. This panel is one of the 12 different panels being offered for 24 continuous hours by bar associations worldwide to celebrate, address challenges, and defend the rule of law. All events are on this YouTube channel. The rule of law is a society's legal underpinning guaranteeing human rights and creating economic opportunity and development, and we lawyers are often the first line of the defense. The rule of law is not merely the stock and trade of lawyers, it is our core value. The universal commitment of the world's lawyers to the rule of law inspired us and many other law societies to join forces and launch this first of its kind Webathon. We are very proud to be a part of that. Before opening this panel, I would like to invite Mr. Christopher Leal, immediate past president of LAWASIA, to say hello to colleagues over the world. Chris, you have a floor.
Thank you very much, Yasushi, and a very good morning and good afternoon and good evening from Kuala Lumpur, Malaysia. I welcome each of you, distinguished speakers, ladies and gentlemen from your respective jurisdictions around the world, to this 7th session that is part of a series of sessions forming the Rule of Law 24 Hours Webathon, Lawyers Around the World, Around the Clock for the Rule of Law. The Rule of Law 24 Hours Webathon, which as far as I know is a first of its kind, is co-organized by Union Internationale des Avocats, for short UIA, the American Bar Association International Law Section, the ABA, and the Human Rights Committee of the Association Internationale des Jeunes Avocats, or AIJA. The 24 Hours Webathon brings together lawyers from around the globe and is dedicated to addressing challenges to the rule of law everywhere. There are 12 sessions of 2 hours each in a series of sessions. The Webathon presents a unique opportunity to bring together various international and jurisdictional law organizations, as well as lawyers with diverse backgrounds, training, experience, and knowledge to share insights into issues pertaining to the rule of law. I'm delighted that this particular session, titled Electoral Democracy and the Rule of Law, is hosted by LAWASIA in collaboration with the UIA, the ABA International Law Section, and AIJA. LAWASIA, otherwise known as the Association for Asia and the Pacific, was founded in 1966. We are an international organization comprised of jurisdictional law organizations, lawyers, judges, and academics from over 40 jurisdictions, mainly from Asia and the Pacific region. Through our member bar associations and law societies, LAWASIA has become the largest platform for lawyers and law associations in the Asia-Pacific legal community. The spirit of partnership, collaboration, and solidarity among our member jurisdictions remain our key strength and has led us to champion an agenda which promotes and upholds the rule of law and confront human rights issues. Ladies and gentlemen, the synopsis for this session starts off by saying, and in keeping with the theme of the title, that democratic elections are often cited as a key component of the rule of law. To me, I think that is a truism. I would also venture to suggest that it is equally correct to say the inverse. That is, the rule of law is a key component of democratic elections. The title thus brings together into play hefty concepts and principles. The adjective electoral relates to elections, and this usually refers to the process and procedures whereby the individual members of a collective choose their representatives. Some would say leaders, but I personally find this to be a misnomer, given that elected persons are to advance and protect the collective interests and to serve the electorate. I think the phrase servants of the people would be more appropriate and accurate. Then next, the term democracy typically describes a system of governance or government where the sovereign power is vested in the people and exercised by them directly or on their behalf by elected representatives. Fundamental features of a democracy are: one, the people elect their representatives and have a right to have regular elections for that purpose. Two, the representatives are, and the government is, accountable and answerable to the people and not the other way around. And third, the individual liberties, rights, and property of the people are sacrosanct and protected by law. I say typically because we see the phenomenon of what is sometimes described as authoritarian democracies, which at best is an aberrational term, attempting to describe a hybrid of authoritarianism and democracy. It may be of interest to you to note that there is an annual democracy index published by the Economist Intelligence Unit, which is the research and analysis division of the Economist Group, which publishes the Economist magazine. The index measures the state of democracy in about 167 jurisdictions and describes them in 4 categories, namely: 1, full democracies such as Canada, Chile, Germany, UK, Spain, Norway, Australia, South Korea, and Japan. 2, flawed democracies, for example, the US of A, Mexico, France, Italy, India, Mongolia, Malaysia, Philippines, Singapore, and Sri Lanka. Thirdly, hybrid regimes, and what I termed earlier as authoritarian democracies, include Turkey, Bangladesh, Fiji, Nepal, Pakistan. And lastly, authoritarian regimes, which include many jurisdictions in West Asia, or what is commonly referred to as the Middle East, as well as Myanmar and North Korea, to name a few. There is a myriad of criteria used to assess, analyze, and slot the various jurisdictions into the 4 categories, such as the level of media freedom, level of civil liberties, political participation of the populace, functioning of government, and the independence of the judiciary. In the context of today's title, the criteria taken into account in this index include: 1, whether there are national, regional, or state elections; 2, whether such elections are free and fair; and 3, the sufficiency of security for voters. I believe that many of us are familiar with the term and concept of the rule of law. Whether the concept is as espoused by Lord Tom Bingham or by Albert Van Dicey it may be discerned that the common principles underpinning the rule of law are: one, the primacy of law, that all are equally subject to it and no one is above the law. And we refer here not to the black letter law, but to the law in terms of equity, fairness, and justice. And two, the effective access to the law. When we merge these concepts in the title of this session, we are in essence putting forth for your consideration how these three concepts interplay. For example, the importance of procedural and substantive fairness in the electoral process in terms of laws that govern elections, constituency delineation, voting facilities, mechanisms and logistics, electoral fraud, security and integrity, political funding, fair access to media, free and fair media reporting, respect for electoral outcomes, and avenue for legitimate challenges. The interplay of these concepts do not confine itself to the elections alone. Electoral democracy and the rule of law relates also to what happens after elections. For example, party hopping and recall petitions, workings of elected bodies, the legislature, executive, and so forth, and respect for electoral outcomes and the giving to effect of it. How often have we witnessed elections resulting in authoritarian regimes? I say, for example, where the electoral process itself does not invite criticism, but the elected persons or representatives then participate in what I would call a hybrid regime or an authoritarian regime. The elected presidency of Ferdinand Marcos of the Philippines in the 1960s and the 2005 election of Hosni Mubarak of Egypt are examples in history. Electoral democracy is not thus about elections itself, nor of the voting, which takes place periodically once in 3 years, 4 years, 5 years, and so forth. People have the right to decide who their representatives are and how they are governed when they go to the ballot boxes. There are examples throughout history and in present day where elected representatives and governments believe that after being elected, they are God sent to govern. Some believe that they should be there forever, and in the doing so, they ignore electoral requirements, constitutional rights of the population are set aside, the electorate are disenfranchised, some are locked up, mistreated, and even shot. These are all against the basic principles of electoral democracy, human rights, and the rule of law. Since early February, Myanmar has faced a rule of law crisis arising from the national elections, when the Tatmadaw, that is, the Myanmar's military, staged a coup d'etat on the democratically elected government led by the National League for Democracy and Aung San Suu Kyi. The resulting public protests led to arrests, beatings, and indiscriminate killings of protesters. Journalists have been arrested, and many lawyers have disappeared. This is deeply concerning. In a post-Trump America, many state legislatures across Republican states are now considering bills which on the face of it look neutral, but are arguably designed to target and disenfranchise minority workers who had overwhelmingly voted for Democrats. Presently, minority voters already face an uphill task in casting their ballot due to voter suppression. These include poor access to voting booths, resulting in long lines and long hours at voting booths. And in Georgia, it is now a crime to give a bottle of water or a snack to people waiting in line to vote or to register to vote. Closer to home for me, Malaysia too is facing a siege on the rule of law. A proclamation of emergency, which was issued early this year, has put democracy and the rule of law into a state of peril. The proclamation of emergency effectively suspended elections and the parliament. In doing so, the executive has assumed the power to legislate freely by edict without parliamentary oversight. Further, Parliament had in 2019 passed an amendment to the Federal Constitution of Malaysia to lower the voting age of Malaysians to 18 years and for automatic voter registration. However, the executive government has failed to implement these as of today, giving rise to allegations of voter suppression in the context of imminent elections, in particular the regional or state elections for Sarawak, which is supposed to be held by 9th August this year. It is to be noted that the principles of electoral democracy and the rule of law apply not only to national, but also to regional, provisional, and state elections. Ladies and gentlemen, I thank you for your time in joining us today. It is hoped that this 24 hours Webathon, which follows the sun around the globe, there will be illumination cast on the many and varied issues pertaining to electoral democracy and the rule of law in the equally many varied jurisdictions around the world, and that it may provide sustenance and food for thought to all concerned. To this end, we are delighted to have 3 eminent speakers who will share their experiences and insights. I'm confident that you will find this webinar session informative and interesting. And on a final note, we at LAWASIA urge governments, whether national, regional, provisional, or state around the world, to uphold the rule of law and to respect and protect the integrity of elections. Thank you, and I now pass the microphone back to Yasushi.
Thank you so much, Chris. Thank you for very comprehensive and informative addresses on the electoral democracy and the rule of law. I know you, Chris, has been fighting for rule of law in your country so long years. So your presentation has a kind of a very passionate effect to us. Thank you.
Thank you very much.
Now, I will proceed to the panel. Before introducing our distinguished speakers, please allow me very briefly to set some foundation of the discussion. This is a guarantee of electoral democracy from human rights perspectives. Some governments would argue that democracy is not a universal because each nation has a right to self-determine their own governance system. Other governments would claim that the formation of democracy is not only one, and democracy can be viable even without election by people. However, those arguments and claims are not true, at least from the viewpoint of human rights. Universal Declaration of Human Rights provides that everyone has a right to take part in the government of his country, directly or through freely chosen representatives. The declaration also affirms that the will of people shall be the basis of the authority of the government, and this will shall be expressed in periodical and genuine elections. Thus, everyone's rights to take part in the government and to express their will through elections are inalienable and should be foundation of any type of government. Such guarantee is succeeded and more detailed by the International Covenant on Civil and Political Rights, ICCPR. According to the Human Rights Committee of the ICCPR, guarantee of the right lies as a core democratic government based on the consent of the people. I actually prepared for more information for you, but I stop here. And now I invite our distinguished speakers for their report and insight from many jurisdictions. One thing for the audience, okay? During the panel, you can pose any questions and comments to speakers by using a chatting function of the platform. I plan to take your input into the discussion as much as time allows, okay? So first, I would like to introduce our keynote speaker of the today, Dr. Mark West. He is an American attorney and anthropologist with more than 15 years experience in the rule of law development worldwide, with a particular focus on South and Southeast Asia. He has collaborated with jurists, civil society groups, and government agencies in India, Nepal, Sri Lanka, Myanmar, and Cambodia, supporting programs on land and labor rights in rural post-conflict settings. Dr. West has directed governance program in Myanmar since 2013. He previously lived in Cambodia, where he worked with US aid programs on right and justice for 4 years, serving as a principal liaison from USAID to the Ministry of Justice. Dr. West holds a PhD from Northern University and a JD from the University of Washington. Okay, now I'd like to listen to your presentation. Mark, please, you have the floor.
Thanks for the introduction. It's great to be here. I want to thank LAWASIA for putting this together. It's no easy task to link the world in a day, all day long, and I'm just very impressed with the whole process. And thank you, Yasushi, for introducing me. And I just wanted to begin by noting that the past president of LAWASIA, Chris, raised a really interesting idea, which is the types of democracies and specifically authoritarian democracies. And so the talk today is really a cautionary tale about authoritarian democracies. And so I want to tell you a little bit about what's been going on in Myanmar. And the best way to understand this cautionary tale is to look at sort of three parts of what's been happening in Myanmar the last few months. You can look at it as the establishment of the rule of law of recent years, and then an election, and then the destruction of the rule of law. And that's what I'll describe today, those sort of three steps. And I think everyone knows, and as we heard from past President Chris, you know, the situation in Myanmar is as he described it. We've been reading about it in the news. It is a full conflict, a civil conflict going on with daily protests by ordinary citizens involved in a civil disobedience movement. There is a general strike underway. The country has really come to a standstill. And of the different ethnic armed groups around the country, which many of which had either peace agreements or ceasefire agreements with the military, the Tatmadaw, which was mentioned by our past president, many of those ceasefire agreements are no longer in play. So there are conflicts, armed conflicts going on around the upland areas around Myanmar. But the core of the story is really this civil disobedience movement going on against the military, which carried out a coup. So the question is, how did we get to this place? And what is the role of the rule of law and elections in getting to this disquiet today? So I'll begin by talking about the establishment of the rule of law. Then I'll talk about the election. and then finally about the destruction of the rule of law and where we are now. So the establishment of the rule of law in Myanmar began only very recently. You know, the story of Myanmar is quite long and goes back millennia, you know, in terms of the conflicts that are going on. You can trace them for many, many centuries. And some of these conflicts still are in place. But really the most significant events leading up to today are really in the last 50 years. So there was a period of about 50 years of military dictatorship in Myanmar. And that's not a, you know, political description, that's just a statement of fact. And the military regime a few years ago, in around 2012, began to soften its position and began to open up. There was a new constitution that the military drafted. There was a referendum on that new constitution in 2008. The constitution itself was in question because the referendum took place right after Cyclone Nargis, which a lot of us know was a devastating cyclone that took the lives of maybe 200,000 people in Myanmar and really destroyed much of the country. So it was not exactly the right time to have a referendum on a new constitution. Nonetheless, it took place. Some people call that constitution the Nargis Constitution. So that took place in 2008, and that set into motion this establishment of the rule of law. The Constitution is important to mention because in it, the military reserved a place for itself in the democracy that was to come. So 1/4 of all of the seats of parliament were to be held by the military, and 3 key ministries were to be held by the military. And those are border affairs, defense, and interior. So the role of the military in this authoritarian democracy was still firm, but nonetheless, elections began a few years later. In 2012, there were some by-elections that were held, and they were won overwhelmingly by the opposition party, the National League for Democracy, which was led by Daw Aung San Suu Kyi, who many of us know. So then in 2015 is kind of the key moment of the first general election. And that election took place. The newly constituted democratic authoritarian democracy allowed it to occur. There was a union election commission which certified the results of the election. And again, the NLD won in a landslide. So this opposition party won by more than 80% of the vote and proceeded to take the country forward. So that's the background of the establishment of the rule of law. Keep in mind that this authoritarian democracy, which some people in Southeast Asia would use a more informal term, we sometimes say a managed democracy, some people say a disciplined democracy. So this managed democracy, with key ministries still being run by the military, with 25% of the parliament still being held by the military, this managed democracy went forward, and the NLD was able to appoint all of the other ministers, and they were enabled to begin to carry out important policies. So that was an experiment in managed democracy for about 5 years, from 2015 to 2020. And I have been working in Myanmar all of that time. And I've been living in the US, sometimes living in Myanmar, traveling back and forth. I have quite a few Myanmar staff. And so I've been able to watch this process up close. I'll move into the next part of the process. So that was the foundation, the establishment of the rule of law. Then came the re-election in 2020. So this is important because this was the moment where, after 5 years of kind of watching this rule of law unfold and watching this process take place without too terribly much obstruction, the military somehow was under the impression that maybe they would make a comeback, and their party, which was called the USDP, Union Solidarity and Development Party, might win the election and might, unseat the NLD, the National League for Democracy. This was a bit of a, misunderstanding on their part. Some would call it sort of a fantasy or self-delusion. But again, in 2020, the election took place. And it was again a landslide for the NLD. More than 80% of the population, of the voting population, voted for the NLD. Now, in both of these general elections, 15 and 20, there of course were many problems. These were imperfect elections. There were many voters that were disenfranchised because of conflict. There were a lot of ethnic armed conflict areas, and we all know about what happened in Rakhine State and the ethnic cleansing in Rakhine State. So much of Rakhine in Western Myanmar was not able to vote. And so, you know, there were maybe 1 million people who were not able to vote out of a total voting population of, I think, something like 20 million people. So there, you know, there were plenty of irregularities in the 15 election and the 20 election. Nonetheless, these irregularities are dealt with as they are dealt with in all democracies. There is a Union Election Commission. In the first general election in 2015, there were complaints by the opposition party, sorry, the USDP, the military party, and those complaints were resolved, and they were dismissed, and the results of the election were certified. Same thing happened in 2020. There were complaints by the USDP again, and they were resolved, and the election was certified by the Union Election Commission. It's also important to note that there were international observers at these elections. So the 2020 election, which happened in November of this last year during COVID, as we all are experiencing, the Carter Center in the United States, which is an important election monitoring body, and ANFREL from Asia were both invited to observe the election, and they had polling monitors at hundreds of sites throughout Myanmar. And the Carter Center, both of those organizations, major independent monitoring bodies, declared that the election was free and fair. The Carter Center in particular issued a statement about the election, and they determined that out of all of the polling sites that they went to, that they assessed the results positively at 94% of the polling sites. So independent observers said that the election was fair and free, and the Union Election Commission itself certified the election and resolved the many disputes that came from the USDP. So this all took place just the last few months. And then come the end of January and the beginning of February, it was time for the new government to sit. At that time, the military had decided that it had not appreciated the result of the election. They were disappointed that their party had lost dramatically. I think the USDP only got about 9% of the vote. And the result was overturned by the military in a coup. So those are the first two things that I wanted to talk about: the establishment of the rule of law, the election process, and now the destruction of the rule of law. So as we learned from the introductory remarks by our past president for LAWASIA, Chris, the military staged a coup on February 1st, and we've all been reading about it for the last 3 months in the news. In a nutshell, they arrested the state councilor, Aung San Suu Kyi. They arrested the president, U Win Myint, and those people have been placed under house arrest. They've had charges against them of, various strange charges. For example, Aung San Suu Kyi was arrested because she had in her office walkie-talkies, which were used by security to communicate to make sure that her office was kept safe. Ironically, the security that were using them were actually the military. It was the Department of Interior, the Ministry of Interior. So, those are the kinds of charges that they were arrested under. After just about 2 or 3 days, February 3rd, February 4th, the public, the sort of shock of the coup began to wear off, and the public realized that this was unacceptable. And since then, we've been reading about what has happened. There have been daily protests in the streets. There has been violent suppression of these protests in the streets, and there's been a general strike, so that the entire country has basically come to a standstill. The ministries are not able to operate very well. The shops, import, export, banking has all really ground to a halt. So in this process, it's important to note, as we heard earlier, that journalists have been arrested, lawyers have been arrested, more than 750 people have been killed. And again, these people are just ordinary citizens who are protesting in the streets. Nearly 4,000 people have been arrested. These statistics come from the Assistance Association for Political Prisoners, AAPP, which is a very highly regarded Myanmar organization of public interest lawyers and human rights workers that have been around for many, many years and have been taking care of political prisoners from the previous regime. And, you know, a couple of noteworthy awful moments. Different MPs, members of parliament, have been arrested. And so this is an example of, you know, authoritarian democracy going off the rails when you start arresting members of parliament and the president and the state councillor. But also, unfortunately, some of these MPs were killed while in custody. So U Zaw Myat Lin and U Kin Mao Lot were both arrested last month, and during their first night in custody, they were killed. So this is the kind of thing that we're dealing with in Myanmar. The rule of law, you know, completely gone. It's tempting to want to, as a lawyer, start to look at some of the, you know, laws that have been amended by the military regime, you know, because one of their first acts was to bring back some old criminal statutes on things like state secrets and on treason. And, you know, as a lawyer, your impulse is to want to start reading some of these and some amendments to laws. And then you realize, and I'd be interested to hear people's comments on this during the discussion, you start realizing, well, what's the point of reading these laws? They don't have the rule of law behind them. They're just edicts by a military regime that has no authority, that has no electoral mandate. And so they could write anything. They could write, you know, the sky is green and call that a law. And is it really worth our time to read them? You know, you start thinking, well, of course, but I have to get to know this criminal statute if I'm going to defend this client who is now in prison. But knowing that the client is going to be railroaded anyway, you just really wonder what is the point of beginning to discern the finer points of these laws. So I think that would be an interesting discussion from others who have dealt with authoritarian democracies that have turned into military dictatorships. So that's the overview of the relationship between you know, an authoritarian democracy that fails, how it begins with the establishment of the rule of law, how it reaches its nadir through a re-election, a second election, general election, and then how it crumbles when the military decides that it's had enough. And I'll just close by noting that I would like to maybe provide a dissenting voice to the idea that we can categorize these types of democracies, because if you do categorize them and state that there are these types and some are more full than others, it does lend some legitimacy to ones that are these authoritarian democracies. And by lending legitimacy to them, we can see what happens. And I myself participated and, you know, worked closely with government in Myanmar on the hope that this managed democracy would turn into something better as the years went by. And many of us did. And, you know, now we're sort of questioning in hindsight, should we have done that? And, you know, so I will leave that as sort of an open question for everyone. And thanks very much for having me. And I very much look forward to the wise counsel of my fellow panelists.
Yasushi, you're on mute.
Yeah, thank you, Mark. Sorry. Yeah, it's a very comprehensive presentation concerning the situation and the historical background of Myanmar. and how the democracy and the rule of law was being destroyed by the military coup. Yeah, it's a very serious situation. One thing, I'm afraid Chris has another appointment, commitment from now on. So during our panel, he might disappear. Okay. Nevertheless, I'm going to proceed to the panel from the various perspectives from the various jurisdictions. Okay. First panel speaker will be the Jerry Ross, Mr. Jerry Ross. Okay. Immediate past president of UIA, the world's oldest and most multicultural international law association, with its headquarters in Paris, France. Jerry is a litigation and trial lawyer in San Francisco at Munger, Torres, and Olson, where he specialized in cross-border criminal and civil matters and international arbitrations. Jerry's firm was deeply involved in much of the federal and state litigation that arose out of the 2020 US presidential election. He will be present some challenges in the United States from a different viewpoint on electoral democracy and rule of law. So, Jerry, you have a floor.
Thank you so much, Yasushi, and it's such a pleasure to be here today and part of this worldwide effort designed to address the many issues being faced by the rule of law. I feel it's totally appropriate for me to be here as a Californian because you represent the Pacific region in LAWASIA, and the Pacific is about a half hour that way from where I'm sitting right now. So I'm happy to be here with my fellow Pacific region folks. As others have already indicated, there is no doubt that electoral democracy is a key component of the rule of law, that consent of the governed is the cornerstone that distinguishes the rule of law societies from those that depend on the will of one person or one group or one part of society without taking into account the entire society. At the same time, electoral democracy faces huge challenges right now around the world, both from societies that have corrupt and phony or meaningless elections, and there are certainly many of those, but also to those that have free and consequential elections. I'm happy to say the United States, I believe, falls in the latter category. Our elections are free, they matter, they have consequences, but challenges have continued to really try electoral democracy. They have been part of our system for many years. New problems have arisen or become more serious in recent years. And we find ourselves now facing a set of circumstances that are really testing our resolve and our commitment to the rule of law in the United States and to our electoral democracy. And we have work to do. We have great work to do to protect our electoral democracy. I believe that realization that we have work to do is growing in the United States. It's perhaps becoming more urgent to many fellow lawyers, but I would say citizens around the country. And perhaps that's why that's what earned us the flawed democracy category that Chris Leong mentioned earlier. Let me categorize 5 broad buckets of what we're seeing or challenges that we see that relate to the legitimacy, the integrity, the fairness, and the consequence of our elections. Some are, as I said, are very long-standing and are built into our system. Some are more recent. First of all, we have serious structural issues from the beginning of our system. There are many now who are questioning whether or not the way in which our system is set up, in which we have a Senate where each state has 2 representatives, and regardless of its population, so that the vote of a person in an unpopulated state or a less populated state ends up mattering more than the vote of a person in a more populated state at the national level, is a very serious structural concern. This is a question that's being raised, even though this has been a part of our system for many years, not from the very beginning, but for hundreds of years of our democracy. Similarly, the Electoral College, and I'm sure you've heard, there are many questions being raised about whether the Electoral College is fair to the majority of people whose candidate ends up not becoming president, even though most people in the country voted for her or him, as the case may be. That is a serious structural question that goes to almost back to the founding of our country, and that is causing great concern and raising serious questions right now. There was a reason for it. The reason was to protect the populations of smaller states and make sure that cities and urban areas and more populated states did not eat up the smaller, more rural areas of the country. But the question remains whether at this point, a majority who sees their candidate winning the most votes but not winning the election, whether those citizens are being treated fairly by our electoral democracy, and whether that is electoral democracy. More subtly, but not very subtle, is a problem that has plagued the United States from the beginning of its history, but that has become much worse in the past, I would say, 2 decades. We've watched it happen. And that's what we call gerrymandering. Gerrymandering means that when you create your electoral districts, as you're going to decide who's going to vote for what person and how you divide up a state or a city or a local area, instead of doing it in a fair, neutral way, you do it to achieve a particular outcome. So you divide an area where you know that a particular party or a particular person is more likely to win, and rather than fairly and neutrally dividing up an area, you do it with that end in mind. And what some people refer to gerrymandering is, it's the politicians choosing their electors instead of the electors choosing their politicians. This problem has become extremely serious in the past 20 years, in large part because most of our states have our electoral divisions, districts created by our state legislatures. And our state legislatures are often dominated by one party or another. So they have every incentive to engage in gerrymandering in order to achieve the political outcomes that they want. And this gerrymandering has had enormous impacts in elections at the state, local, and also national level over the past 20 years. Beyond these structural issues, which I consider bucket 1, there are enormous issues, and Chris alluded to these rightly, of voter suppression. And voter suppression can be very blatant. In our history, we've had periods of time where there were masked riders on horses who kept minority voters from voting. Yes, we had that. That's not, it can exist nowadays, but it's certainly not common. However, we have come up with other ways to suppress different groups from voting, many different ways. And they're more subtle and in many ways more devious, and Chris mentioned some of them. It's where you set up voting booths. It's what rules you choose to set up those booths or those locations. It's what days you pick for people to be able to vote. It's what hours you set for people to be able to vote. It's whether you permit mail-in voting. It's what kind of identification you require at the voting station. And by piling on all of these different requirements, you can achieve an extraordinary amount of voter suppression. And as we know, we are seeing it now being legislated into state law in various places around the country. This is a very devious and very serious threat to our democracy, which I know that many of us lawyers around the country are looking to challenge as soon as some of these rules take effect. But this has been going on for many years and has had a serious impact. There are also other ways of suppressing the vote, and that's by choosing who gets to vote. We have a rule in the United States, many countries do, but not all, that somebody who has committed a felony can never vote again. You're a felon forever, or you're a felon for a very long period of time, even after you have finished your sentence, even after you have paid your price back to the community for having committed a crime, even after you have paid your fines, even after you've done everything that society has asked of you, we still say you cannot vote. What is the basis for that? On what right do we have to permanently take away somebody's right to vote because of the commission of a crime? That person is still a member of society, still impacted by the government that is being elected by everyone else around him or her. And this has given rise to a bunch of other questions about our rules about who gets to vote. How old do you have to be? Should people in high school be allowed to vote? Is it fair to deprive them of a voice? Yes, they're not as mature as, some are not as mature as some older people, but there is but some are. And there's a real question now about what the appropriate age is and whether or not we are in some sense disenfranchising some of our youth who are such an important part of our community and somebody whose lives, people whose lives are so dramatically affected by our government. A third bucket of challenges, and all of these are very of the moment in the United States, is how we verify, what processes we use to verify the various aspects of voting. How do we count votes? Who oversees that? Who handles a challenge to a vote? Yes, you want a verification process to avoid fraud, and fraud is a problem around the world, we know that. But a verification process handled in a inauthentic or improper way can be used to undermine the legitimacy rather than reinforce the legitimacy of election, and can be used to change results that you don't like. We've seen that. We've seen challenges to elections that are without basis. And those challenges are designed to change the results rather than to correct some problem that actually occurred. We see that with respect to verifying whether people who voted were eligible to vote. We see it with respect to checking signatures. We see it with respect to whether or not addresses matched. You can imagine a set of requirements that becomes simply onerous and impossible to meet and legitimize that set of requirements by saying it's all designed to avoid fraud. And we see this happening increasingly in some of our states, and it's becoming as much a problem as some of the other means of voter suppression. We all remember what happened in the United States in 2000 when we had issues about verifying literally the logistics of voting, whether or not the ballot was properly cut or pierced by the voting mechanism. And we had our famous litigation about hanging chads. And there again, we had challenges to what appeared to be legitimate votes. We had litigation about it. And that began a 2-decade-long process of challenging processes as a way of trying to change election results. There's also there's a new issue, and I want to mention it because it became quite important and we were involved in this litigation. And that's the fact that the US Constitution places the responsibility for federal elections in terms of setting the rules for federal elections with state legislatures. And it specifically says the state legislatures get to set those rules in each state. The problem with that is that state legislatures never act in a vacuum. They enact laws, which are then implemented by local officials. They're reviewed and implemented and interpreted by administrators. And of course, they're subject to review by the courts. Well, this year with our 2020 election, many took the position that accommodations that were made to take account of COVID and difficulties that people had in reaching ballot boxes were illegitimate because they had not been approved by the state legislature, even though they had been approved by the appropriate executives, appropriate local officials, or even required or approved by courts. Taking that line in the Constitution and saying anything that isn't exactly the word of the state legislature is illegitimate. So this issue began to be litigated. There was no final conclusion on it. And many of us anticipate that this is an area where we're going to see a lot of litigation in the United States in the future, and a lot of challenges to otherwise legitimate elections based on the notion that somehow the state legislatures laws were not followed or were interpreted or were somehow amended by these other authorities. Let me talk about two more problems that we are facing. One is money. As many of you know, in 2010, the Supreme Court decided that corporations had a right to communicate, to speak, to free speech on elections. Not only corporations, but also all associations, including labor unions. And that has given rise to an enormous hundreds of millions of dollars per election being poured into our election, which has an extraordinarily distorting effect. It takes the voice of regular people and it effectively mutes it in favor of the voice of wealthy corporations and wealthy unions. And many, including our former President Obama, but not just him, see this corrosive effect of money as being one of the most distorting effects on our elections. And at this point, only getting worse with higher and higher amounts of money being spent even on local and less significant national elections, such that when I watch television at night during an election season, the program is a few minutes, but the commercials are the bulk of what I am watching. I am watching one advertisement after another, all of them paid for by these committees, corporations, and the extraordinary amount of money flowing into elections. It's a very, very serious problem, and it distorts democracy. And I would be remiss not to mention the fifth category, which we have all been exposed to, and that is the extreme partisanship and division that we are seeing in the United States, in large part due to social media and to cable news media. We have, both on social news media and cable media, we see the extremes favored, vocal, and self-aggrandizing. And by that I mean they speak and they speak until everyone in the middle slowly moves to the ends, and we are all a society divided. And that has basically stopped groups of Americans from speaking to one another, and instead has them speaking at each other in a hostile, I don't know what other word to use, hostile, aggressive way that achieves nothing, but that sends our elections into a very, very serious, dangerous spot. We also see the use of false information, and this has been a huge issue in the last election. You can basically say anything and use the First Amendment and free speech as a cover for saying pretty much anything, whether or not it's true. So is it a crime to say my opponent favors taking money from poor people? It's not a crime. You can get away with that. It may have absolutely no truth, but you get away with it. And now we see social media taking these ridiculous false statements and propagating them, and causing our society to become so divided that our elections are corroded by them. And I would just add, on top of all of that, that we see news media and liberal and conservative news media taking increasingly entertainment type positions, things designed to excite and inflame rather than to inform and educate. And that too is having a very corrosive effect. When you take all of these 5 buckets, you have a serious problem, a serious challenge to a great democracy. And I am optimistic because I hear more and more people recognizing the danger and the threat. And I hope that we will seize the problem and that lawyers in particular will enter the fray in support of true democracy. But that remains to be seen. And unfortunately, optimists are sometimes wrong. So with that, I turn the floor back over to you, Yasushi, and thank you very much for the opportunity to speak.
Thank you, Jerry. Yeah, actually, everybody observe the United States is a kind of a role model of democracy and the rule of law. But Jerry frankly presented many challenges which currently the United States are facing with in the implementation of democracies. Yeah, I think it's a very interesting point, and we can share those challenges with other jurisdictions as well. Chris, are you still okay with us, or want to say one word?
Yes, I'm just staying on because my appointment is just about 45 minutes away. Yeah, thanks.
Now, I'd like to pass the floor to the second panel. Is Mr. Jeffrey Lee. Mr. Jeffrey Lee, he is an attorney in Taiwan and belongs to the dispute resolution practice group of prominent law firm of Lee and Lee. In addition to international arbitration and civil litigation, he is experienced in the administrative appeals and litigation cases. Jeffrey is also an expert in the field of constitutional law and litigation. He wrote multiple books and articles in the field of public law, litigation, and arbitration. Okay, Jeffrey, you have the floor, and I appreciate your presentation. Okay.
Thank you, Yasushi, and to all distinguished speakers. So it's my pleasure to have this opportunity to share the Taiwanese experiencing democracy and rule of law with all the international experts in this meaningful forum. So as a public law practitioner, especially in administrative law and constitutional law, in the past years, I've actually handled a couple of election-related cases. And today, I will pick one of them to focus on an issue in our presidential election. And mainly the issue is about the eligibility requirement issue. So to echo with Yasushi and Christopher's statement of the rule of law, one of the very important element of rule of law is people's equal right to access to government, to participate in government. And normally we are talking about people's right to vote, but people's right to be elected is also a very important thing we need to take into consideration. So before getting to the specific issue I'm going to talk about, I'd like to draw attention to some background knowledge about Taiwanese democracy. So Taiwan had a martial law between 1948 to 1987, and the martial law was ended in 1987. And from 1987 until today, we have experienced 3 decades of democracy's development. And also we have experienced 3 successful and peaceful presidential transfer of power between 2 dominant parties, namely the Kuomintang KMT and Democratic Progressive Party DPP. And according to a recent democracy poll results made in October 2020, actually 80% of Taiwanese people believe in democracy in 2020. Compare with the rate 62 in 2014, actually the rate increased almost up to 20%. So people in Taiwan do believe in democracy. And last year, we just finished our presidential election. The turnout exists to almost 75%. And actually the average rate is 70%. And the DPP Ms. Tsai Ing-wen president actually won the election both in 2016 and 2020. And one fact it's worth to mention, and will also lead to the issue I'm going to talk about today, is that there are no non-party endorsed candidates actually appeared in 2016 and 2020. So take 2020 as an example. The three candidates, all from three different parties, DPP, KMT, and PFP, is a very small party. There are no non-party endorsed candidates. So what is the presidential eligibility requirements providing in our law? In addition to a very standard requirements, specifically that you have to have the residency, you have to the domicile for a specific period of time in Taiwan, and the age must be over 40 years old. That's, I would say, I think will be the common requirement, as I also hear the similar requirements from Jerry in the United States. And we have the other two, I would say, special requirements if you want to become a presidential candidate. The first one is you have to have certain endorsement. The endorsement either from political parties endorsement, or if you're a general citizen, you need to gather the petition, the general support from other citizens. If you have no partisan endorsement. And also you have to provide the registration deposit, a certain amount. So I'm going to revisit the requirements. And basically, there are three requirements. If I'm a general citizen, I'm a people without partisan support, partisan endorsement, how many? What will be the threshold I need to meet if I want to become a president candidate? There are three requirements. First, as I mentioned, you should prepare a petition, and that petition, you should acquire the signatories of at least 1.5% of the total number of electors in the most recent election. Second, you have to pay a security deposit for the petition. And if the applicants fails to reach the half of minimum minimum petition signatories as prescribed, the deposit will not be returned. Third, in addition to the security deposit for the petition and the petition itself, you have to, if you successfully become a candidate, then you have to pay another registration deposit, and that will not be returned if you receive votes less than 5% of the total electors. So I'm going to put some statistics to these three different requirements to let you better understand the three requirements. About the petition, in 2020, actually it requires 280,000 jury signatories, and each with national ID cards. Yeah, it will be, and it was examined in written form by the government. And in fact, from 1996 until 2020, there are only 5 candidates over 33 groups reached the threshold, and none of them won the election. And in 2020 itself, 8 applications from candidate registration, none of them reached the threshold. So you can see from the statistics, it's a very, very high bar if you want to successfully pass the threshold for joint signatories. That's the first one requirement. About the security deposit for the petition, the number required is around US $35,000. And the threshold for return of deposit in 2020, as mentioned, half of the joint signatories. So it will be of 140,000 joint signatories. And actually, a group, as I mentioned, application, none of them succeeded in reach the threshold. In other words, our government actually confiscate all the security deposit for petition. As for the third requirement, finally, the registration deposit, that's a high amount of money. You have to pay another, once you become a candidate of the presidential election, in addition to the security deposit for the petition, you have to pay another candidate registration deposit. And the number as required is around $535,000. And it's worth to mention that among three groups in 2020 as the presidential election, one group, James Song, the candidate of PFP, People's First Party, failed to reach the 5% threshold. So actually, the registration deposit was not returned. So that's the three special requirements for the presidential election candidate. And actually, in 1998, we have a case to challenge the constitutionality of the relevant requirements. So the Constitutional Court handed down interpretation number 468 in 1998. And unfortunately, the Constitutional Court during that time held that the requirements, namely the petition and the security deposit for petition, is constitutional. And the reason used by the court is that those requirements are to prevent people from needless participating in presidential election and to preserve social resources. And it's difficult for us to know that what's the standard for the court to determine necessary or unnecessary participation in an election. And also, how come balance with the right to be elected and the social burden or social cost as claimed by the court, how come the social preservation of the social resources would prevail? And it's very interesting to mention that in interpretation number 468, the Constitutional Court actually emphasized that they do know that the relevant requirements shall be revisited in due course because the social political landscape will change, the democracy will develop. So the relevant requirements can be revisited in due course. From 1998 until 2020 or 2021, 23 years has been passed after the interpretation number 468. Certain factors has changed to demonstrate that it's time and it's mature for us to revisit this issue. That we have experienced 6 successful and peaceful presidential elections after 1998, and as I already referred to, 3 presidential transfer of powers happened. And most importantly, in 1998, we are in an age of paper processing. And we are turning to digital processing, now even to AI processing age. So it's time to rethink whether it is still feasible for us to ask to examine in written form of the petition, page by page with national ID card. So I would use a case of mine to conclude my remark. Our client is Shiming, the former chairman of DPP. So he wished to become a candidate back in 2015 for the 2016 presidential election. So he applied for become the candidate. However, he was not able to provide the security deposit for the petition. And therefore his application was rejected, and we act on behalf of him to file the case to the administrative court. And as expected, the court dismissed our case. So we filed a petition to the constitutional interpretation back in 2019, try to challenge the requirements and petition to overrule the interpretation number of 468. And our arguments basically is very, very simple. Article 25 of our CCPR, as well as our Articles 7 and 17 of our Taiwanese Constitution, all guarantee people's equal right to be elected and access to public service. And as I already tried to argue, that rule of law at least protect people's equal rights to be selected into the government. And to me, or to us, the three requirements, not to mention that I learned from Jerry pretty well that in the United States, they don't have the special requirements like us. They only have the basic age requirement and the nationality requirement. And I learned from Jerry that even those requirements may be unconstitutional or may be challenged. So I see no point for our law to put a heavy burden on people need to prepare petition, a huge amount of petition signatories. And also you have to provide a huge amount of money for security deposit, registration deposit. Because whenever you try to get to devote yourself into the election, you already have to invest a lot of money in fact. And I don't see there's a justification for a law to require people to put the deposit and confiscate it if you fail to meet certain threshold. That will create a result, also referred to by Jerry in his previous statement, that may result an outcome that only rich people may have a right to participate in the government election, to be selected as a president. And that's not inconsistent. It's not just consistent with the rule of law and our expectation of the democracy. So thank you for your time. That shall conclude my remark. And I would like to hear more perspective from other jurisdictions about, and are your comments about the requirements for the presidency eligibility requirements. Thank you.
Thank you, Jeffrey. You pointed out a very important and different aspect of the democracy, as a right to be elected. And as you mentioned, Human Rights Committee of the ICCPR repeatedly said any conditions on exercise of those rights should be based on objective and reasonable criteria. Also, persons who are otherwise eligible to stand for election should not be excluded by unreasonable or discriminatory requirements. So your point is sounding unanimously with a point Human Rights Committee always pointed out. Thank you. Now, we are very lucky to have another panel from the jurisdiction of Hong Kong. Mr. CM Chan, who is the Vice President of Law Society of Hong Kong. And we all understand now the people in Hong Kong is facing very changing challenges currently. So I'd like to listen to voices, perspectives from Hong Kong lawyers. So thank you, Mr. Chan, for joining our discussion today. You have the floor for a few words.
Thank you, Yasushi. First of all, I must admit that this is sort of a last-minute invitation. There's some confusion whether I will be a speaker or whether I will be speaking from the floor. Doesn't matter. I think it's worthwhile, and I'm so glad I attended this morning's lecture, hearing from our past president, Chris Leung, usual eloquent way defining the rule of law, whether it's the Dicey formula or the Lord Bingham's formula, his usual eloquent way. I'm so appreciate that I'm here. Also, very appreciative of Mark's comments updating us about the situation in Myanmar, which actually have some relevance in terms of comparison to Hong Kong, when you talk about whether we should just obey the law if the law itself is not a just law. This is a very interesting point, especially from Hong Kong's angle. Again, a very, very good speech from Jerry, pointing out a lot of uniqueness in the States about its election system, electoral system. Hong Kong is actually undergoing a massive reform of its electoral system as we speak. And the point Jerry really touched me is the polarization. It's exactly happening in Hong Kong as well. Either you are pro-government or you're anti-government. There's nothing in the middle. So the solution for myself is stick to the law, look at the law, and analyze it without taking into account the politics. We all know the problem in Hong Kong is complicated because of China. International politics, there's an effort to discredit China in many ways. So for me, at least I have to stick to the law, look at the constitutional framework in Hong Kong before jumping into conclusion. And of course, many thanks to Jeffrey updating us the position in Taiwan. Taiwan is always close to my heart. In fact, funny enough, my last trip, overseas trip, flying out of Hong Kong is to Taiwan in January 2020 to observe your presidential election. That was my last trip because of COVID. And then I was stranded in Hong Kong all these 18 months. So without further ado, in the next few minutes, I'll try to convince you, of course, it's all my personal view. I'm not representing any organization. Try to argue that while there is no Western-style democracy or electoral system in Hong Kong, which is a quite complicated situation now, Hong Kong, the rule of law in Hong Kong is still very robust. And I still have full confidence in Hong Kong courts. I hope to be able to convey that message in the next few minutes. So in order to do that, we should take a little bit history lesson here. Why are we here, Hong Kong? Of course, as we all know, Hong Kong was a British colony before 1997, results of some wars between the British government and the imperial Qing dynasty, the Chinese government. They call it Opium Wars, there are a number of them. The last one in 1860 resulted in a treaty which Hong Kong was sort of leased to the British for 99 years. The lease ended in 1997 and hence the handover in 1997 of sovereignty from British to China. So Hong Kong used to be a colony. And we all know that in the 60s, the UN passed a number of declarations on the so-called self-determination for colonies. The British and the Chinese government always said that Hong Kong is exempted, and in fact, Macau as well, another Portuguese colony. They are not part of the self-determination mechanism under the UN, because from China's side, the Opium War, the treaties, they are all called unequal treaties. They are the treaties are a result of military force. So the Chinese government never recognized those Opium Wars treaties. So 1997 is sort of like a convenient date from China's point of view for return of sovereignty. So since the 80s, the British government and the Chinese government started negotiation on the future of Hong Kong. And in the end, they signed a joint declaration, Sino-British joint declaration, which is they use the word very carefully. They call it a declaration, not a treaty, but it's actually registered in the UN, this joint declaration. When you carefully look at this joint declaration, it's basically China saying that, oh, I'll do this after the handover. And the Brits said that, okay, we recognize all that. And that's why we're handing back the sovereignty to you in 1997. There was no mention of universal suffrage in the joint declaration. There's no mention of one man, one vote in the joint declaration. On the other hand, after the handover, the constitution, the constitutional document for Hong Kong is a document called the Basic Law, which is a piece of legislation passed by the National People's Congress in Beijing. So that's a domestic law. In the Basic Law, there's actually a promise that the Hong Kong legislature and the chief executive, which is our leader, will be ultimately chosen by universal suffrage. However, it must be done in an orderly manner and taking into account the actual situation in Hong Kong. So these are the words used in the Basic Law. So I repeat, there's no promise from the British side under the Joint Declaration, but there is a promise by the Beijing government in the Basic Law. Okay, so fast forward. Hong Kong's been in the news in the past few years. Most notably in 2014, there was an umbrella movement, which is a movement mostly peaceful in 2014 by the students calling for more democracy, calling for a lower threshold, exactly the point Jeffrey's been making, for candidates to be the chief executive. They want a lower threshold, easier to be a candidate. Beijing has some reservation. They said because the actual situation in Hong Kong is still unknown, so we need to be a bit more careful. So that was basically the argument in 2014, umbrella movement. And then came 2019. The Hong Kong government tried to introduce an extradition bill, quite a technical bill. In fact, when I looked at the provisions of the bill, it's actually very similar to international extradition mechanism. Duality of crime, so it has to be a crime both in Hong Kong and in other countries before you can extradite something. There should be a sort of a safeguards before you can extradite a fugitive, because that guy is still not a criminal in Hong Kong, not convicted. Anyway, caused a huge discontent in Hong Kong. The law not targeted at China, but the citizens of Hong Kong with deep distrust with the Beijing always thought that, oh, from now on with the extradition bill, normal citizens in Hong Kong can be extradited to Beijing very easily. That's actually not the case if you read the bill carefully. Anyhow, the bill was controversial, caused thousands of people coming out on the streets to demonstrate. The government actually backs down in the end. Very early on, the Hong Kong government backs down. Okay, we're withdrawing the bill. We will not put forward this controversial bill anymore. But the protesters now ask for more. They want more democracy. So it turns out a huge movement since 2019. All the way up to 2020, middle of the year, Beijing said that the only way to end this unrest, social unrest, is I will enact a national security law from Beijing National Imperial Congress to be applicable in Hong Kong. It did the trick. It did the trick. You know, the protests basically more or less stopped or calmed down a lot since the national security law has been in place. But of course, then people started accusing China of being, oh, you are so heavy-handed. You are destroying one country, two systems, which is the model under the Basic Law. Hong Kong's supposed to have self-autonomy, and you are now enacting a law to be directly applicable in Hong Kong. Oh, so you're destroying the system. But again, when you look carefully at what the Basic Law said, it's actually well within this mechanism. There is a mechanism under Article 18 of the Basic Law allowing, in certain circumstances, Beijing, when it feels necessary, will include some national law to be applicable in Hong Kong. One example is the national anthem, national flag, national emblem. These are national symbols, so it's a national law but applicable in Hong Kong. True, Beijing never include anything so detailed or with a criminal consequence like the national security law in Hong Kong. But from Beijing's point of view, that's the only way to stop the unrest. Otherwise, one country, two systems cannot continue, at least from their perspective. So after the national security law in 2021, quite recently, the National People's Congress in Beijing made another decision to reform Hong Kong's electoral system. Well before 1997, I mentioned that Hong Kong used to be a British colony. We never had any democracy in Hong Kong anyway. Only towards the final years leading up to the handover, Chris Patten, the last governor, did try to introduce some sort of democracy in Hong Kong legislature, but that's only too little too late. So the funny thing is, in Hong Kong, we never had any democracy, but we always have a very independent judiciary. I must also mention that the two International Human Rights Convention, ICCPR, are actually well included in the Basic Law. It's actually in our constitutional framework. So all the local laws has to be compliance with the two International Human Rights Convention. That's very important. The last point I want to make is our very unique Court of Final Appeal system. After the handover, the Basic Law, our constitutional document, guarantees judicial independence in Hong Kong. It's written there. More importantly, it set up a Court of Final Appeal, which has had the final power to adjudicate cases in Hong Kong. Of course, there are exceptions if it deals with national security or things that outside of Hong Kong's autonomy. It involves the whole of China's national interest that Hong Kong does not have the power to deal with them. I'll come back to that later if I have time. But in any event, the Court of Final Appeal does have the final right power to adjudicate, replacing the Privy Council of the House of Lords in the UK before 1997. A very special feature, which I haven't actually seen anywhere else in the world, is in the highest court in Hong Kong, we have foreign judges. Usually, the Court of Final Appeal, there are 5 judges, a panel of 5 judges. One of them is called an overseas non-permanent judge, which can be invited from other common law jurisdictions. So there's now at present a panel of 14 foreign judges. 10 of them are from the UK, 1 of them from Canada, 2 from Australia, none from the US. But this is a very unique feature of Hong Kong's court system. I haven't seen any sovereign country in their highest court allowing a foreigner to sit there to make judgment. It has the same power of the other 4 local judges. And in fact, this foreign judge in the past 24 years after the handover did make a lot of contribution in terms of their judgment. They make comments on the local laws, whether, like, for example, like I said, whether a local law is compatible with international practice, with international norms, with international human rights convention. And this is actually, to me, is the best guardian of our judicial independence. Unfortunately, in the past 12 months, there have been a lot of political pressure from the UK government, parliamentarians, newspapers, press. They're asking for these 10 UK judges to withdraw from Hong Kong's Court of Final Appeal because Hong Kong is no longer a place to respect human rights. Why are you borrowing your name to a dictatorship? I end my talk with not the exact quote because I can't remember. Lord Sumption, one of the 14 foreign judges, who is a very prominent UK judges, now retired from the UK Supreme Court, but now sitting on the Hong Kong Court of Final Appeal. He said that he will stay on no matter what other politicians are going to say. Because from his point of view, Hong Kong, the rule of law in Hong Kong is robust. And this is actually the best time to remain on the Court of Final Appeal because of the new national security law. The law will go through the Hong Kong court system and ultimately will reach the Court of Final Appeal. And these foreign judges will actually be obliged to apply international standard to the national security law and the electoral reform that I referred to earlier on. So from that angle, I am still confident, at least from the rule of law point of view, we have a very independent and high standard judiciary. And I really, really hope that that can maintain. My final words, I mentioned that in the Basic Law, it promises a universal suffrage ultimately for our legislature and our chief executive. And I'm glad that Beijing actually said that that's still the aim, even though there's no particular timeline. But Beijing reiterated that the ultimate goal for universal suffrage in Hong Kong is still there. So on that remarks, that's the end of my presentation. Thank you.
Thank you, Xian. Yeah, Actually, I understand it's a very complicated situation in Hong Kong. And as you presented, no democracy but independence of justice, rule of law can be viable. It's a very important questions for everybody, for us. Okay, so now we have one keynote speech and three presentation from the different jurisdictions. Also, Chris mentions a very comprehensive perspective on rule of law and democracy. So now I'm using the remaining time for some exchange for your views. But we don't have so much time. So I'd like to ask you make some comment among the challenges you already mentioned. What kind of role the lawyers or international law organizations, bar associations can play to improve the situation in each jurisdiction? It's a very difficult question because in Myanmar, people are being killed by the military and totally denied the result of the election. On the other hand, several jurisdictions, the government put some unreasonable conditions on the elections process. So the situation and the challenge are very different, but still, I think you can make some insight about the role of lawyers on the situation. So I'd like to ask each one of you about that point to make some comments. So can I ask Mark first?
Thanks. That's a great question, and it's actually helpful for me because there was one point that I didn't make during my remarks, and this was exactly the point. So what are some approaches that international lawyers can take to try to contribute to a positive outcome in Myanmar? So it's important to note that there is a democratically elected government, and during the coup, the members of parliament who had been elected 3 or 4 months earlier were actually in the parliament, and they live in a members housing, like a dormitory. And so when the coup took place, they were all placed under house arrest there at the parliament. And while they were there in their first few days, they would have none of this, and so they convened parliament while under house arrest. And so the government was actually convened. And then, of course, they were immediately, hustled out by the military and told to go home and carry out their house arrest at their respective constituencies. So nonetheless, they remained in contact in an official capacity, and they drafted a new constitution. And these members of parliament rescinded the old constitution and enacted the new constitution with their supermajority that they had. And going forward, there is now a national unity government. So this is a government, as you can imagine, on the run, in exile, some of them, in India or in Thailand, some of them in Myanmar. But nonetheless, they've begun to appoint ministers, and they are beginning to issue various policies. So I give that as background to say that I think the role of international lawyers, in my view, is to advise this national unity government, and they are seeking advice. There is a committee representing the upper house of the parliament. They have websites, you can find them, and the constitution is available online. And so I think that this is a very interesting moment in history, and we've seen this in a bunch of other countries where you have these transitional states, and we saw in Libya, for example, we've seen in Kosovo, we've seen in Cambodia that there have been these transitional state moments where you'll have an exiled government that has legitimacy, but it's not safe for them to return. And the international community should support that national unity government, meaning international lawyers should support them, advising them on their legal development. Thanks.
Thank you. Yeah, it's a very important point, kind of international judicial assistance, which can be done by international organization of lawyers. Yeah, that's a very important point. So, Jerry, you have some comment about the role of lawyers and the international lawyers organization?
I do have thoughts, and I've thought about it quite a bit because it's a little tricky. To be very honest, the voice of international lawyers can have the opposite effect in the United States because many of our citizens see that as interference from outside, and their gut reaction or their immediate reaction is to say, whatever you're saying doesn't matter because you're not in the United States. And that's part of that kind of very independent, somewhat nationalistic mentality. That said, you know, some of these points, some of the points and problems I made earlier are really questions of weighing different values, weighing free speech against false information, weighing protecting against fraud, against weighing using fraud as a way to delegitimize legitimate elections. And I do think that the international community can play a really important role in helping sort of balancing those different competing values and coming up with a recommendation or ways in which to approach those kinds of competing interests that could be useful in analyzing the situation we have in the United States. And may I take a moment, Yasushi? I actually have a question for Mark very quickly. Mark, I found your comments fascinating. Do you feel that because the military was embedded in the government from the beginning, as you mentioned, which I was unaware of in that way, that this was a situation doomed to fail? In other words, were the seeds of what happened included in the origins of this budding democracy? And maybe that's what we mean by saying an authoritarian democracy, such that there really was no other outcome that we really could have expected?
That's that's a tough one, Jerry. I'm of two minds on this. I still actually believe that it was on course and that it maybe was going to be a slow course. Maybe it was never going to really flourish. And maybe it was always going to be a managed democracy where there would be this elected party and then the military controlling these other ministries. The 25% of seats that the military had in the parliament was a check on changing the constitution, because you have to have 75% of the votes plus one, basically, in order to change the constitution. So that was their effort to protect their position. But you know, that said, there were efforts by the NLD to try to amend the constitution. But really the view, you know, and now you're starting to get into culture a little bit, you know, the Buddhist culture and the Burma view there in Myanmar, and you know, there was this view that they could cooperate, and that there, you know, in the West we have this kind of separation of us and them, and there they had more of a unified view of we. And so there was this sense that Aung San Suu Kyi and the NLD could cooperate with the military, and eventually, after a period of, you know, maybe 2 or 3 or 4 more elections, could get to a reform place. So I'm still kind of a believer in that. The seeds were, you know, to answer your question directly, the seeds were definitely there. I mean, you know, that's undeniable, the seeds of the authoritarian reversal. But I have to say, you know, since you had your excellent remarks about the US, it was not just a coincidence that what was going on in the United States with our own election and the questioning of our own election at that same time, because our election in the US was November of 2020 and the election in Myanmar was November of 2020. And those who watched the US election and the discrediting of the election by the losing party, I don't think that that was lost on the military. I think they were paying attention. And when that culminated in the invasion of the Capitol building, you know, I can't imagine that the military wasn't looking and saying, you know what, maybe this is our moment to seize the election in Myanmar, and the U.S. and others will not be in a very strong position to push back.
Okay, well, thank you.
Okay. Thank you, Mark. So Jeffrey, Shem, so you have a final comment? In particular, is my question I posed.
Okay,
Jeffrey.
so yeah, thank you, Joshi. So I will have a quick response to the inquiries of you about the lawyer's role. I will use 3 points to answer this question from Taiwan's experience. The first point will be, so in many important disputes, actually our bar associations, different bar associations will make public declaration to each of the important issue. And normally those position is related to constitutional law and rule of law. So the basic position is set by our bar association. I think that's a very important role established by all the lawyers in Taiwan. Second point, you can see from the past the movement in streets that many lawyers will stand with the people to ensure that whenever there's arrest happen or criminal prosecution happen or administrative agencies mandatory action happening, that lawyers will ensure due process function as well, very well in accordance with the rule of law in our constitution. So that's a very important role for our lawyers on street. The third point would be to echo with the case I just handled with. So people may know Constitution and they believe in Constitution and democracy, but whenever there's systematic issue happening, there's democracy's system conflict issue happening with the constitutional law, then the lawyers will stand with people to help them to assert their right to practice the constitutional law. And I think that's the role we lawyers are now doing. So we act on behalf of our client to challenge the current system, the current democratic system in different cases. Whenever there's election dispute arising, the lawyers play a very important role to practice constitutional law and rule of law to try to make the realization of people's right of democracy. So that's the 3 points I'd like to make in response to your inquiries. Thank you.
Thank you, Jeffrey. So CM, you have a word?
Yeah, thanks, Yoshishi. The role of lawyers in Hong Kong is so very important. Hong Kong still use the old British system. We have two legal professions, the barristers and the solicitors. Only the England and Wales, only South Africa, I think in the world, still retains two separate professions. But that's important. The two law associations in Hong Kong are self-regulatory. We are not answering to the government. It's a self-regulatory system here. So we issue licenses to lawyers, solicitors, if they want to practice as a solicitor. By the same token, the barristers, they have their own admission system. Nothing to do with the government. So that's important actually to enhance the rule of law in Hong Kong. I'm not only talking about the moral high ground of human rights, things like that. But from China's point of view, Hong Kong's still most important role of Hong Kong is still as the platform for international trade, using Hong Kong as the springboard. Because of Hong Kong's unique legal system, the only city in the whole of China that practices common law, utilizing Hong Kong's special feature to help China to integrate into the world. I still think that's important. This is actually getting more difficult, as you all know, because of the trade war between US and China. Hong Kong's role is now sort of diminishing because the US started to sanction many Hong Kong citizens and organizations as well. So it's getting more difficult. But to me, I think the lawyers in Hong Kong, we all swear to uphold the rule of law. We have a very unique constitutional framework I just described, which in a way, to a certain extent, comply with international standard because of the ICCPR. So let's work within the framework, fight for what we can have in Hong Kong within the framework, and contribute to China. After all, the most challenging thing is China being a socialist system, Hong Kong with a common law capitalist system. The interface between the two systems is so challenging. So lawyers has a big role to play in all this. Thank you.
Thank you, CM. Now I'm closing this panel. Today we have discussed the various aspects of electoral democracy and the rule of law, focusing on jurisdictions in Asia Pacific. I believe we learned a rich experience and perspectives from speakers. Nevertheless, I also understand that there are many other aspects which have not been addressed in today's discussion. One of those missing aspects is a perspective of gender gap. I know that in many countries, including my country of Japan, gender gaps such as political candidacy or facilitation of voters still impede full realization of electoral democracy and the rule of law. I will leave those remaining issues to further future discussion. Our unprecedented 24-hour Webathon, lawyers across the globe around the clock for the rule of law, does not stop here. At the top of the hour, we will go live to Philippines to join the Philippine National Union of People's Lawyers for a panel discussing government persecution of lawyers, the role of international bar. Okay, so please join the following event discussing the rule of law. Okay, so today I thank all distinguished speakers and contributors, Dr. Mark West, Mr. Jerry Ross, Mr. Jeffrey Lee, and Mr. CM Chan. Also, I thank audience for joining this panel. I close this panel now. So have a
Thank you,
nice
Yasushi.
Yeah.
Thank you. Goodbye, everybody.
Thank you.
Thanks, everybody. Learned a lot.